I'm absolutely delighted to come here. As usual, as you know, I'm very familiar with Galway, and not only am I involved at a management level, but I also have a granddaughter student here in the law school, so that I'm familiar with it from, as it were, both ends of the spectrum. And I'm also extremely delighted to listen to Brice Dickson and to comment as best I can on what he has said, which I found really a remarkably good analysis of the Irish Supreme Court, and I'm certainly looking forward to his work when he has finished it. He talks about what he said as being merely a kind of starting point. Well, he has certainly started in the right direction as far as I'm concerned, and while obviously I would know most of the things that he has said, I know them in sort of bits and pieces, and it was great to have them sort of pulled together in the way that he has done it. And as I say, I largely agree with what he has said. I just will make a few comments because in fact, in many ways, I feel I could talk on and on for ages about this, and I don't want to do that because I'd like to leave some room for discussion. First of all, when he talks about saying that he was speaking on what he didn't know, well, I don't agree with that at all. I think he knows very well what's going on. But I do agree that there hasn't been much analysis of the Supreme Court, and interestingly enough, I don't think I'm giving away secrets on this, but the new legal correspondent of the Irish Times is extremely interested to write an analytical article about the Supreme Court. And in fact, I did a long interview with him the other day, and I was enabled to talk both on the record and off the record, as it were, about the methods of work of the Supreme Court, which people seem to be very curious about, and I'll refer to that a little bit later on. I think what's very important too is where Brice has said that there are all legal matters and that it's not just a constitutional court. And this, as has come out at intervals in what Brice has said, I think has been a weakness of the Supreme Court and a difficulty of the Supreme Court, and certainly from the point of view of being a judge in the Supreme Court, puts an enormous amount of pressure on the court. And the fact that every High Court appeal, every High Court case can appeal to the Supreme Court, and the Irish people are litigious people generally, and when they lose in the High Court, they have a great love of appealing. And so even though not all of these appeals actually go to hearing, I mean, I do recall that at one stage we had a special list for the dead cases that had put in appeals but never really progressed them. And 3 of us used to sit every Wednesday morning for an hour or so just to call up various barristers and saying, what do you think you're doing with this? You're sitting here for a year and a half and you haven't even put in a piece of paper, and we're striking you out if you don't move, sort of thing. So that the fact that so many decisions are made, and that so many, well, that means that quite a number of decisions are extempore decisions, which is a bad principle. I mean, very few of us are able to give an extempore judgment and that it will turn. And see, the trouble is it's recorded and you see it back to you again. And it's only when you see what you said, and this is particularly true of the Court of Criminal Appeal, of course, which is generally headed by a Supreme Court judge. It's only when you see what you actually said in your extempore judgment that you realise how badly you express yourself and how your sentences ramble on from line to line, as it were, and the examples of bad grammar that you may very well use in your speech. So that, I mean, it's a bad thing that this should happen, but it happens because of pressure of time. And again, the pressure of having to write so many judgments has to be divided out among the various judges so that you get fewer, there's a sort of pressure to have fewer cases where you'd have several judges writing a judgment, because if you know, the temptation is if you all agree at the end result, that one judge will write the judgment for the court. And then the other judges have, while they might have felt that they could put in a few helpful extra bits, as it were, if they did a separate judgment, at the same time they're very conscious of the fact that there are 6 more judgments sitting in a line waiting to be written, and you just haven't time. So that I think it's hugely important that the new appeal court should come about. And if there is a referendum about this, may I pray that you all vote for it, because I think it will make a huge difference to enable the Supreme Court, as properly constituted, to deal with cases that are genuinely legally important or are constitutional matters. So I absolutely agree with Brice, and I would more than do that. I would say this is really, really important. I mean, you've only to look at the fact that at the beginning, as he has said, there were only, a handful of judges in the High Court, and now we have, I think it's 28 or 29, and obviously that means there's loads and loads more cases, and also loads and loads more appeals, which has meant that even though at the time that I was in the Supreme Court, by an immense effort, we managed to reduce the backlog to about 6 months. It has now expanded again to about 4 years, and it's totally unsatisfactory that litigants should be left waiting for 4 years to know. I mean, I realise, of course, that the European Court of Human Rights is, if anything, much worse in this, but it is really wrong, and I hope that if the new Court of Appeal is set up, that some of the really rubbish cases that go to the Supreme Court now, and when I say rubbish, I don't mean that they're not meaningful to the litigants, but if you're going to spend, we used to have groups of cases that were heard on Friday afternoons that it consisted of things like assessment of damages that was appealed, and that's not the proper thing for a Supreme Court to be doing, really. Now, he also went on to talk about the peculiarities of the Constitution and the Article 26 reference situation, and I was involved in a number of these myself, including the one about the developers having to put a certain proportion of their developments into social housing, which I think we definitely made from my point of view at any rate, the right decision about, but which did cover a considerable argument about how the right of property was included in the Constitution. But the weakness of Article 26 a priori references under Article 26 is, of course, that you haven't seen at all how the legislation will work out in practice, because it's only just gone to the President for signature. And you have, normally when you listen to counsel arguing cases, they're arguing about the realities of what this legislation means, how it's the weaknesses or strengths of the legislation who developed, and what it says to the person on the ground. Whereas in a priori reference, the two counsel who are there, well, there's the attorney and his or her counsel on one side, and a chosen counsel on the other side, and they are forced to argue it kind of with a background of nothing, as it were, with no facts. And judges are very fond of having facts, and there's kind of no facts in these arguments. So that I do think that there's a difficulty about that. Nevertheless, I do think it's an important thing to have. But I think that when you're looking at that you have to remember that there is a certain weakness. I also do think it's a pity that we have to have just one judgment. I mean, I'm a great believer in the having minority judgments, and very often, I mean, as you know, as time goes by, sometimes the minority judgment turns out to be the more important in the end than the major judgment. And some of the questions that are that have been referred in Article 26 references really could benefit from having judgments from a number of judges. The Article 45 Directive principles, I find they're kind of irritating in my view, because they set out all these ground principles, but they're absolutely not much use to you at all on the way in which they've been interpreted over the years. So that I'll skip over that because I really can't say anything very useful about it. Of course, I see I mean, we all know, and you will all know, the sort of history of the 1960s, 1970s. One thing I think is just kind of interesting is the number of the plaintiffs in these cases that established principles were women. I mean, you talk about, I remember hearing Mary Ellen Ring, who is now a judge of the Circuit Court, of course, being asked to give a talk about women in the law, and everybody expected her to get up and talk about how women barristers get on and whether there's gender discrimination, etc. Instead of which she just stood up and said, well, the most important women in the law were like Mrs. Byrne, who fell into a post office hole and set out and they changed the law entirely. Mrs. Ryan, who objected to fluoride put into the water supply. Mrs. McGee, who was looking for contraceptive rights. Ms. Anderson, Ms. Burke and Ms. Anderson, who got rights for women to be put on juries. And I can't resist telling you that at one stage I was sitting in the criminal circuit court overseeing the impaneling of a jury. And lo and behold, who was called up on the panel but Ms. Burke, who was the lady who had initiated this case. And of course, I would have known Miss Burke, but as soon as Miss Burke stood up, the State Council stood up instantly and objected to her. She didn't actually get onto the jury herself, and both she and I just laughed. You know, what do you expect? I would hold. I agree, of course, with Gwyn Morgan that Ireland likes underdogs, and I'm inclined to say, aren't they right to like underdogs? That generally speaking, the individual as against the state has comparatively little power, and without some kind of form of judicial review to, as it were, uphold the rights of the individual against the state, I think we would be much more poorly off. And I feel that the fact that, generally speaking, there is, perhaps a landlord and tenant might go a little too far, but generally speaking, I think that is right, and I would, and it worries me, in fact, that the nature of our judicial review has become sort of limited, and from cases like Stardust, O'Keefe and Stardust, and onwards, that the whole concept of unreasonableness and the way in which judicial review itself is interpreted seems to me to have narrowed wrongly. And all the time that I was in the Supreme Court, I was hoping against hope that we would get a case which would enable the court to widen judicial review somewhat in the way in which the English courts have widened it in some of their later cases. So that I think we have the conservatism of the court is shown in the way in which judicial review is interpreted, and I think that is something that needs looking at. I also agree about the conservatism of judges, and I've given a number of minority judgments myself, but which reflect that in a way. And I think that we have gone through a period where the devotion to the separation of powers has reached a kind of peak, which has gone much too far, much too great deference to the state in their lauding, as it were. And of course, the separation of powers is important, but in a country where the legislative arm of the three powers, the legislative arm is extremely weak as opposed to the executive power, as we can see in the operation of the Dáil and Senate as it works now, where the government basically, particularly when you have a government with as large a majority as we have at the moment, when a government is as powerful as that, and the average legislator who is as powerless, I think it's important that the judicial arm of the state should not be overly reverential and overly saying, well, this, that, and the other is the separation of powers, when it means looking at the interaction between individuals and the state. And I think probably all of you have a very good idea of which judges are particularly keen on the separation of powers, and I don't want to go into personal analysis of that sort, but I'm sure you do know. Perhaps as the time is going by very rapidly, I might just say that I was very interested in, I recently, on last Tuesday, as you probably know, took part in the continuing debate about the X case in the Oireachtas Committee on Health and Children. And it was interesting to have the quite embittered argument continually being made that the judgment of the Supreme Court in the X case was a flawed judgment, and that therefore absolutely no notice need be taken of it, and that the legislation could proceed to ignore the law as set out by the Supreme Court judges. This statement was, I felt, largely made by people who had never bothered themselves to read the judgments, and the careful analysis made in particular by Chief Justice Finlay of the harmonious interpretation of the Constitution, which had to take into account not just the amendment of the Constitution concerning abortion, but also the family articles of the Constitution stressing the importance of the mother and the dependence of the family on the mother, and the weighing of the two situations. But it was more the fact that it had, while it would be accepted up to, in other cases, that what the Supreme Court said was the law, that if you didn't like the judgment of the Supreme Court in this particular case, you could just ignore it and move on, as it were. So I think that's a dangerous kind of argument, and an unconstitutional argument, in fact, but it's dangerous that this should kind of get about and perhaps spread out from the particular argument that it's about. There are other cases, there are other areas where obviously more needs to be done, like, for instance, the rights of unmarried fathers, where our law, to a large extent, continues to ignore the decision of the European Court of Human Rights, and unmarried fathers are still suffering from discrimination under the law. And I would agree that this court had become very conservative. On the other hand, I think if you do have to look at who's in which. I mean, everybody knows that if you're a counsel appearing before the Supreme Court, the first thing you look at is to see which judges are on that particular court. And it does seem to me that there have been a number of, if I might put it this way, more imaginative appointments in recent years into the Supreme Court, and I look forward to a change to a rather less conservative approach, provided that the newer judges can withstand, as it were, the continuing influence of those who are already established as powerful judges on the court. And I think that we could see a change to a bit more judicial activism at least, and certainly that's something I would like to see. I'm afraid I've run over time, but by my usual temptation to talk more than I should. But I hope that there will be some time, Marie, for questions and so on. So thank you very much.